as you can see, we have participants from New Brunswick, the East Coast, and all the way to British Columbia. So this was a coast-to-coast national workshop. Ki soki ukiet. Okay, nape, danse, anin, wig, yotes, OCM, hadi. My friends, good afternoon. My name is Rob Louie. I said hello to you in various First Nation languages, the Kootenays, the Blackfoot, the Cree, the Ojibwe, the Haisla people up in northern British Columbia, the Coast Salish folks in and around the Vancouver Lower Mainland area, and the Shuswap, and then I capped it off with the Carrier First Nation in northern British Columbia. As mentioned, my name is Rob Louie. I am the president of the Band Members Alliance and Advocacy Association of Canada. The acronym is BMAC, so if you wish, you can just call it BMAC. And please note, there are 3 A's in BMAC, not 2. Sometimes folks will only put 2, and then in which case the message doesn't get to us. First things first, I'd like to acknowledge my spouse, Mariah Big Sky, who has done a lot of work for BMAC, and she's the technical side of this. So a lot of the credit goes to her for this. As well, I'd like to acknowledge that I am in my home ancestral lands of the Dunacha First Nation. Dunacha translates to licks the blood. So we are known as the licks the blood people. The English term used to be the Kootenays, and we are in southeastern British Columbia. We are also in northwestern Montana and northern Idaho, so we are on both sides of the border. I am very pleased to have with us today Caitlin Long from the international law firm of Norton Rose Fulbright. She will be presenting first, and I'll allow her to introduce herself shortly. As well, we're grateful to have the presence of Dave Oswald, who is a forensic accountant out of Ontario. You guys are here to see them, and I'd like to now turn the floor over to Caitlin to discuss our topic today, First Nations forensic audits. Caitlin, the floor is yours. Thank you very much.
Thanks, Rob. I'll just try to share the right screen here. And everyone, Dave, can you see that?
Yeah.
Okay. So good morning or afternoon to everyone, and thank you very much for having me here today. As Rob said, my name is Caitlin Long, and I'm a partner in the Calgary office of Norton Rose Fulbright, so I am on Treaty 7 territory, and I'd like to acknowledge that. I do regularly practice in the Aboriginal and Indigenous law space on both the advisory and dispute sides while maintaining a regulatory and commercial litigation practice. So Dave and I have split the presentation today where I will start with an overview of the rights First Nations members have vis-a-vis their chief and counsel for financial information and ways to enforce those rights. Dave, who has considerable experience in this area, will then get into forensic audits and how to use those. He's definitely the expert in that area. So the starting point for a discussion of rights to information in a First Nation is what are the obligations owed by chief and counsel to its members? As many of you likely know, chief and counsel are in a fiduciary relationship to the First Nation as a whole and to individual First Nation members. And a fiduciary is where one party has placed its trust and confidence in another, and the latter has agreed to act in a manner consistent with that trust and confidence. So a fiduciary has to act in the utmost good faith towards its beneficiaries, and that includes a duty of loyalty and a duty of equal treatment between members. This means that they have to act in the best interest of both the nation and the membership in almost all decisions. That's especially ones involving the finances of the nation. That raises 2 other duties. One, chief and counsel cannot put themselves in a position where their personal interests conflict with those of the nation without express authority to do so. And 2, they cannot profit from their position as a fiduciary, and it must account for any benefit or gain obtained if they do. Now, that last one is obviously apart from salary or normal compensation for acting as chief or counselor in the first place, but that's also an exception where in setting individual chief and council salary, that still has to be strictly complied with and often requires publication of the bylaw or resolution to the nation's members about how that salary was set. In the case of First Nations, as I said, chief and council owe a duty to both the nation as a whole and to individual members. This means that there can sometimes be conflict that arises when chief and council are trying to determine, for example, how to spend money, whether that goes towards nation objectives or whether that goes towards, for example, per capita disbursements. So where are different sources of money coming from? There are a number of them. First, there's two that are still controlled by the federal government for specific bands that are under the Indian Act. That would be through capital monies and revenue monies. Capital monies are derived from the sale of capital assets that belong to a First Nation or lands that have been surrendered to the Crown. And revenue monies are basically all other monies that have been collected, received, or held by the Crown for the use and benefit of a nation. So why am I talking about these two separately? Well, these two categories can typically only be spent if the federal minister authorizes the expenditure. So as long as the minister, in his or her opinion, believes that the purpose is for the benefit of the nation. And that again can include per capita distribution. But where the minister is the source of the authorization, it is unlikely that chief and council have fiduciary duties for those two categories. For these other four categories, the chief and council's duties are engaged. So this includes revenue monies where a nation has assumed control under the Indian Band's revenue monies regulations. It includes if settlement money has been paid into trust and chief and council are made trustees, then chief and council has to follow the strict terms of the trust in dealing with those monies. If they are not made trustees, then they have actually no say over how the money is distributed. Commercial income, that can flow from either nation-owned companies, other enterprises, or agreements with third parties, such as impact of benefit agreements. This money, as well as damages from court cases that are not paid into trusts, are at the full discretion of chief and council to be spent, but are still governed by those overarching fiduciary duties. While chief and council must operate under these, it is unlikely that incompetence or poor results would result in a finding that a chief or councillor has breached their fiduciary duty unless it's paired specifically with dishonesty or disloyalty. Now, there are a few formally protected ways for members of a nation to assess whether or not chief and council are meeting their fiduciary obligations as it relates to financial accountability. These include the Access to Information Act, the Indian Act, and the First Nation Financial Transparency Act. I'll address each of these in turn, but I also want to highlight that asking for the information you want from chief and council is important. One, you may actually get the information, which is great, but even if you don't, you're building a case to show the efforts that you went through before escalating to other avenues. And having that evidence that you asked and were denied is very important in certain court cases if you go forward with that avenue of holding your chief and council accountable. So first, under the Access to Information Act, there are a number of financial statements and records that First Nations must file with the Minister of Indian Affairs pursuant to the Indian Band's revenue monies regulations. Those are normally deemed to be confidential records within the meaning of Section 21B of the Access to Information Act. That basically means that the public can't access those records. But the federal court has made an exception and recognized that where a First Nation's financial statements actually will be subject to disclosure under the Access to Information Act is if the person requesting it is a member of that First Nation. And that's because members do have a legal right to review their own nation's financial statements under the revenue monies regulation. Therefore, an avenue to access financial information, including a spectrum of information apart from just financial statements, is through the federal FOIP process or through an information request to what is known as the Crown Indigenous Relations and Northern Affairs Privacy Coordinator. That's an informal process that you don't have to kick off a full FOIP, but you can just ask the coordinator for the specific information that you're looking for. That information can include, but is not limited to, records relating to First Nation elections and election appeals, records relating to the composition of chief and council, lists of banned bylaws and council resolutions, records relating to the ownership of land on reserves, and also impact and benefit agreements that have been made with the Crown. So this just shows what a formal access to information request looks like. It costs $5. It can be mailed or completed online. Things to be very mindful of, and I'll just read from the slide here, is that to be pretty detailed when describing the records you want to get. Don't formally request like a specific title information unless you know the exact documents you're looking for, but putting time, like date times like 2015 to 2023, putting very information about looking for financial records or audited financial statements or other audit documents is important to put in there. The government is required by law to respond to a formal request within 30 days, but that can be extended if the government thinks it's necessary to consult with Chief and Counsel before releasing that information. So it might extend that time limit. Usually it can extend it quite a bit, but it's still something to start as a process to have going in the background while you are trying to find financial information. For First Nations that are not governed by the Indian Act, they have the capacity to create their own legislation in accordance with that nation's constitution. A handful of First Nations have created their own legislation regarding privacy and access to information. And these statutes or processes give members or other qualifying persons access to information and records that are under control of that respective First Nation and provide procedures for actually obtaining the information. This also ensures that there's a framework in place that's been accepted by leadership and the First Nations members that will survive elections. So it is really important or great to have this in place because it sets a standard of behavior and conduct that would be hard to dismantle once it's in place by future leadership. The Indian Act also provides some access to information to members of First Nations as listed on the slide. This information is not typically financial. It's more so about the governance of the nation, including access to bylaws and access to council meetings. Regulations to the Indian Act do mandate that audited financial statements are to be posted in public places on reserve and that members have a right of access to review those records. Finally, there's the First Nations Financial Transparency Act. This act mandates that every First Nation must prepare consolidated financial statements in accordance with generally accepted accounting principles. Upon the request of a member, a chief and council have to provide the band's audited financial statements and the auditor's report, a schedule of remuneration and expenses, which sets out the remuneration paid and the expenses reimbursed to the band member's chief and each of its councillors, and the auditor's review report regarding that schedule. The federal government does maintain a website with this information, and most First Nations do comply with the provisions, even though the federal government doesn't enforce the act at this time. And while, as I said, the federal government doesn't enforce it, that does not mean First Nation members cannot enforce it in themselves. So the FNFTA provides an avenue for members to pursue these financial records through the courts. And a First Nation member who requests but does not receive this information from their chief and council within 120 days after the end of a First Nations fiscal year can apply to the court for an order compelling the First Nations chief and council to provide the reports. So this slide is just to show where you can access this information, where the FNFTA stuff is actually posted on the federal government's website. I'm sure most of you know that this is here and have accessed it before. And once you choose a particular nation, you can just go to this spot, the FNFTA, and it will show up whether it's being posted or not. There has been engagement on whether to rescind or amend the FNFTA, which started in 2018. There was engagement to that effect where a bunch of survey results were taken. That survey indicated that 97% of respondents agreed that First Nation members should have access to information on federal funding decisions. 99% of respondents agreed that First Nation members should have access to their First Nations financial information. And 81% said that an independent body should ensure that the federal government is accountable to First Nation communities on financial matters. And while not shown particularly on this slide, respondents did indicate that for those of them that did access First Nation financial information in the last 2 years, almost 70% of them accessed it via the federal government as opposed to the First Nation itself, which might show that there's a gap in transparency requirements. So then what can First Nation members do to access financial information apart from a FOIP request and after you have requested the information from Chief and Counsel but been denied or ignored? So I'll cover litigation-based avenues as well as non-litigation-based avenues, starting with litigation. So there are two different ways to challenge a denial by counsel for certain information. The first one is a judicial review, and the second is an application to a superior court. Now, once you find information and maybe find that Chief and Counsel are not dealing with the nation's finances correctly, then a whole avenue of actions also opens up as well, including criminal charges, civil actions, etc. But I'm limiting my comments right now to just getting that information in the first place to make those inquiries. So starting first with judicial review, this is the most used route taken by members that are unhappy with a First Nation Council's decision, including where council may deny a member's request for records or for drafts of a policy. In a judicial review, courts review the actions and inactions, decisions, or orders of a government or public body to determine whether they are legally valid within the statutory authority provided. So where a band council is exercising authority as elected leaders, it does constitute a federal board. That's important because the availability of judicial review is actually under the Federal Courts Act. So if you're going to pursue judicial review of Chief and Counsel decisions, it has to go through the federal court. In order to start a judicial review process, there's a form on the federal court's website, Form 301, and the application includes details of the decision being reviewed, a description of the requested relief, such as the production of documents, and a list of affidavits to be relied on. That is a document where someone describes what has happened, i.e., I requested this information and I was ignored, and appending copies of any documents that are relevant, such as a written request that was actually made to Chief and Counsel for information. And then it also includes a list of documents requested from Chief and Counsel if they're not in possession of the member. The application has to be filed within 30 days of the date Chief and Counsel's decision was made, and that can be extended in certain circumstances. A filed copy of the application is delivered to Chief and Counsel as well as the Attorney General of Canada. And when filling out your application, you just have to be very clear about certain points. If Chief and Counsel failed to do one or more of the following, such as they were not impartial, they weren't fair, they didn't let you be heard, they didn't give reasons for their decision, etc. A second avenue, which I've kind of already covered for challenging a decision, is through the First Nations Financial Transparency Act. That provides its own avenue for challenging a decision of Band Council to refuse to disclose financial information. So where a member's request for information falls within those two types, so audited financial statements or the schedule of remuneration and expenses, a member can apply to a court to get those disclosed. Usually that application has to be made within 1 to 2 years of a failure to provide that information. Now, I know that's a lot of information and that starting a court action can be a bit daunting. And so I did want to say, as part of our mandate with BMAC, being Norton Rose Fulbright's mandate with BMAC, we are providing model forms for filing this kind of action, the FNTA action with the court. So those forms, which include an application, a draft affidavit, a memorandum of argument, and a draft order, are going to be available through BMAC by the end of the year for you to use. So while it's not exactly having a lawyer in your corner, it does provide a set of materials for you to work from if you want to pursue, again, audited financial statements or the schedule of remuneration through the courts. Those model forms will be there for you to use. And even with those, if your nation is not one that's actually complying with the FNFTA, we have found that sometimes just filing those documents in court will result in your Chief and Counsel giving you the information without you actually having to pursue the entire court action. So a recent successful case under the FNFTA involved Charmaine Stick and Onion Lake Cree Nation. Mystic was supported by the Canadian Taxpayers Federation in her application. The initial decision by the court ordered Onion Lake Cree Nation to provide Mystic with certain financial records relating to 2015 and 2016. The nation did appeal, but was unsuccessful before the Court of Appeal. And then Onion Lake posted on the internet the requested records within 15 days. However, it has not done so since that time. So if you go on to the federal government's website, all financial records pre-2015 are not disclosed, and all financial records post-2016 have not been disclosed, which would, in theory, if the request for relief was not amended, would mean that you'd have to do another application to get those subsequent years. So there are non-court avenues for obtaining information as well. This includes the FOIP process that I previously mentioned, being the formal request or an informal request to the Crown Indigenous Relations and Northern Affairs Privacy Coordinator, which is a bit of a mouthful for a title. But you can also file a complaint to the Assessment and Investigation Services branch. That will investigate complaints about the conduct of First Nations, Inuit, or Métis government bodies and the way that funding from the federal government is administered through those bodies. So a complaint will also start a process to try to get more information to you. Also, if you know that your particular nation has dealings with a company that extracts resources from your reserve or from a traditional territory, you can also go to that specific company's website to see if it is a reporter under the Extractive Sector Transparency Measures Act. That act requires certain companies of a certain size to disclose any money that they're providing to First Nations, and that would kind of give you the ballpark of the amounts that are being provided to your community if it is a reporter. Over the longer term, honestly, the best way to ensure financial disclosure and accountability is by formalizing structures and processes within the First Nation itself. So this can include the full range of policies that are outlined on the slide. Sometimes we found that even when seeking transparency from chief and council, it comes down to just a miscommunication or a misunderstanding about what can be shared between chief and council and the membership of a nation versus what is confidential. And so I know sometimes there can be an initial reaction to not sharing anything because they don't want to get in trouble regarding confidentiality obligations, or leadership may be so busy that it fails to communicate. But putting these kinds of policies in place can help with that by setting clear guidelines and expectations on both sides. Even if that's not the case, even if it's not a miscommunication or a misunderstanding, having these types of processes formalized within the First Nation means that there's a structure to hold leadership accountable and sets up a set of standards that are very helpful in a potential lawsuit if necessary. So if chief and council has these types of policies and has these sets of bylaws set up, it makes it a lot easier for members to hold leadership accountable if they're not met. So it sets out basically a cause of action for you to pursue so long as these are in place at the time. It also sets the tone for leadership that accountability is at the forefront of members' minds. And when they come in, they have an understanding of exactly how communication with members should happen. Oops. Okay, so I'm missing a particular slide. So what happens if you do eventually get the information? Well, there are more steps that are likely going to be needed. Even once you get it, someone has to look at that information and determine if anything wrong has occurred or whether more information is needed. If that does happen, if you find that something has gone wrong, there's a number of things that can happen, including charges under the criminal code. So we've looked at those for breach of trust by a public officer, fraud, secret commissions, which are basically kickbacks, or embezzlement of funds. We've seen that sometimes dealing with nation-owned companies. There can also be civil actions that can be started in the name of individual members for breach of fiduciary duty, fraud, breach of trust, conversion or misrepresentation. So there is a range of causes of action that are available once you kind of understand that the information is leading you down a path of bad actions. So with that, I'm going to turn it over to Dave, who can really talk about those next steps in the process from getting some initial information to the investigation. Just have to figure out how to stop.
Thanks, Caitlin.
Yeah. Do you know how I stop sharing?
Just stop sharing.
There you go. Done it. Okay.
And right, and let me share my screen. Where am I? Share screen. Okay, everybody. So,
can I ask a question?
yeah, sure.
My name is Bernadette. And so when you were talking about applying for information, does it have to be can it be a registered member, not a band member? Because sometimes there's like, you know, I just want to be clear around that, because I know that some people or some bands have band members and then they have registered members who are not band members. Could they still ask for information?
I think it depends on your specific, how your specific nation is set up, but I would still ask. And then if they deny it on the basis of your standing, then try to find someone who is a formal member.
Everyone's kind of scared. I noticed that they're scared to ask questions because of the backlash or the retaliation. So is there another mechanism to document that as well when you're asking information?
Yeah, so there is another avenue. So for example, under the FNFTA, you can have, I think, an interested party start the action as well instead of an individual member. So you saw that the Canadian Taxpayer Federation kind of intervened and also pursued the information. There may be an opportunity for other organizations to pursue it on behalf of members. It's just more likely for the court to actually give the order if it is a member, but you can also try it through, you know, kind of an interest group to apply under a different section for that, for those financial statements and the schedule of remuneration. That doesn't get you the full range of other information that you can get through a FOIP request. And just through FOIP, I don't think in that particular federal court decision where it said, you know, a First Nation member isn't subject to the exclusions of confidentiality under the FOIP Act, I would assume, and this is just me assuming, that member would be as defined under the Indian Act for you to be able to make that FOIP request for that exception. And then for questions in the chat, just while Dave is talking, I'm going to put in the information that's been requested. But if there is other information than those chats, then I can take it now or wait until Dave has finished.